Hello everyone and welcome to the second of our video tutorials on offer and acceptance in contract law. Today we're going to be looking at acceptance. Once valid acceptance of an offer takes place, a binding contract is formed, so it's therefore very important to know what constitutes a valid acceptance in order to establish if the parties are bound by the agreement or not. First important thing to look at when looking at acceptance is the fact that acceptance must be unconditional. And acceptance has to be differentiated from a counteroffer. A counteroffer is where an offeree responds to an offer by making an offer on different terms. And this has the effect of destroying the original offer so that it's no longer open for the offeree to accept. So I'm going to explain this a bit further for you by looking at the case of Hyde and Wrench. And you can see it's an ancient case from 1840. What happened here was the defendant offered to sell a farm to the claimant for £1,000. And in reply, the claimant offered £950. And this was rejected by the defendant. Later, the claimant tried to accept the original offer of £1,000. But there was held to be no contract because this counteroffer here of £950 had impliedly rejected the original offer of £1,000. And at that point, that offer is destroyed and is no longer capable of acceptance. So the principle here is that any attempt to change the terms of an offer is a counteroffer and not an acceptance. And when we say acceptance must be unconditional, what we mean really is that acceptance must be a mirror image of the offer. So if someone offers me something, Lucy, would you like to buy a kitten for £700? And I say, oh yes, I'd like to buy a kitten for £700. That's a mirror image of the offer. So that's an acceptance. If I'd responded by, oh, I'd like to buy the kitten for £650, that's a counteroffer which has destroyed the original offer of £700. So any acceptance must be unconditional for it to be valid. What can make this area a little bit more complicated is that you also have to differentiate between a counteroffer and a request for further information. So Stevenson and McLean here are defendants offered to sell goods at a set price. And the claimants replied saying, would you deliver over 2 months? And no reply was received, but the claimants nonetheless accepted the offer. And in this case, it was held that there was a binding contract. Now, if you think back to Hyde and Wrench, some of you might have been thinking, well, if there's an offer, and then they've replied by saying, can you make the delivery over 2 months? Some of you might have thought, well, surely that's a counter. But the court said that this wasn't a counter offer. This was simply a request for further information because it wasn't actually changing the terms at all. So you've always got to have a look at your scenario and think, is that comment simply a request for further information, or is it a counteroffer? If it's just a request for info, you can still accept the original offer. So to give you a kitten example of this, to make it clearer perhaps, if someone says, Lucy, would you like to buy a kitten for £700? And I go, yes, can I pick it up on Tuesday? The can I pick it up on Tuesday is simply a request for further information. That's not a counter offer. So you've always got to look at your scenario and think, is it just wanting more info or is it actually changing the terms? Another important rule for acceptance is that it must be communicated to the person who's made the offer. Silence can never be an acceptance. And that's even if the offeror says, I'll accept silence. And there's a practical reason for that. If I were to say to you very quickly, I'll sell you a kitten for £700, no need to reply, I trust that no reply means you've accepted. That'd be ridiculous. I'd be able to form contracts here, there and everywhere. So silence cannot be an acceptance. And you can see that in the ancient case here of Felshouse and Brindley. And the uncle wrote to a nephew saying, quote, "If I hear no more from you, I shall consider the horse to be mine." You can't do that because the non-response is silence in essence, and silence will not amount to acceptance. Sometimes the person making the offer may specify how they would like the other party to accept the offer. And we saw this in the case of Yates. And in this case, it was about a piece of land that was being sold. And it said that if you want to accept, you must do so in writing, sent by, quote, "registered or recorded delivery post." So they've specified there how they want the acceptance to arrive. Now, this person must have been a bit of a cheapskate. They didn't want to pay for recorded delivery, so they just sent it by normal post. And in this case, the courts held, well, their acceptance by normal post is not valid because it's not what the person asked for. So your acceptance can be invalid if it doesn't comply with the specific form required by the offer. So look closely. If they say accept by phone or accept by post, that's going to be the method that your person needs to use. Another important issue to look at is what is known as battle of the forms. And a battle of the forms arises when two businesses are negotiating the terms of a contract, and each business wants to contract on the basis of its own terms. And you'll see that where business A offers to buy goods from B on A's standard terms, and B seems to accept the offer on the basis of its own, B's own standard terms. So they look like they're accepting offers with their own pre-printed forms. And in this situation, the battle is going to be won by the party who, quote, fired the last shot. This is known as the last shot rule. So the last party to put forward terms and conditions that were not explicitly rejected by the recipient will be the ones that are accepted. Very important rule to look at when looking at acceptance is the postal rule. And where it's agreed that the parties will use the post as a means of communication, the postal rule will apply. And the postal rule states that where a letter is properly addressed and stamped, the acceptance takes place when the letter is placed in the post box. And this comes from the case of Adams and Lindsell. The facts of Adams and Lindsell are that the defendant wrote to the claimant offering to sell them some wool and asking for a reply, quote, in the course of post. But their letter making this offer was delayed in the post. And on receiving this letter offer, the claimant posted their letter of acceptance on that same day. But due to the delay that had happened in the post, the defendants assumed that the claimant was not interested in the wool anymore and sold it on to a third party. And the claimant was suing for breach of contract because in their mind they'd accepted the offer. And the court held in this case that there was a valid contract which came into existence the moment that the letter of acceptance was placed in the post. And this case, as I've said, established the postal rule. The case of Household Fire Insurance and Grant is another case on the postal rule, and it shows how sort of extreme, if you like, the postal rule is really. So the postal rule applies even where the letter of acceptance is lost. So acceptance is valid on posting. So even if the letter of acceptance never arrives, it gets destroyed, that doesn't matter. The acceptance is valid the moment it goes in the post box. So look out for that in scenarios. If they're accepting by post, it's valid the moment they put it in the post box, regardless of whether it gets there or not. Now, whilst all this sounds quite harsh, the postal rule, it is relatively easy for parties to avoid the postal rule. So you can see that might be quite inconvenient for businesses. To not know if a party has accepted or not, to be waiting for the post, to be wondering about whether things are delayed in the post. The case of Holwell Securities provides a solution to that, really. And in this case, the defendant offered to sell his house to the claimant, but said that he required, quote, notice in writing. And what that phrase means legally is that they actually have to have read it. So if the defendant specifies that they actually have to receive the communication, that means that the postal rule won't apply and that you need actual communication to form the contract. So if they don't mention it, postal rule applies, but parties can avoid the postal rule by stating the letter must be received, or the letter must be read, or I must have notice of it. And that will mean that you can avoid Adams and Lindsell. The courts have also had to consider when acceptance will occur with other methods of acceptance. These are known as the modern methods of communication, fax and telex, although they are pretty dated to you and I. But in terms of contract law, they are seen as being quite modern. So in the case of Torres, Denning found that the regular postal rule didn't apply to telex. So for telex, acceptance occurs where the message is read. But is that of significance to us now? Really, we don't use telex anymore. A much more useful case to us is Thomas and BPE. And this case was where the court had to consider acceptance by email. So should the postal rule apply or should it not? And what happened here, we had a judge called Blair J, and Blair said that the postal rule is likely to apply to email, notice likely, so that means if you get an offer and you accept by email, it is likely that your acceptance occurs the second you hit send on your email. But he did say that the outcome will depend on each case and on its own particular facts. And he said that it will depend on context, intentions of the parties, and also, quote, sound business practice. So what he's really alluding to there is that depending on the size of the business, what the offer on acceptance is, the value of the product or the service that's being sold or exchanged, that's going to affect whether we think it's fair or not to have the acceptance valid the moment that we hit send. So unfortunately for us lawyers, it means that you have to give a bit of a it depends type answer if you've got an email, although it does seem likely that we would follow the postal rule. Just to summarise what we've seen on acceptance there, that acceptance occurs when an offeree agrees to be mutually bound to the terms of the contract. We've seen that the acceptance must be unconditional. It has to be a mirror image of the offer. If it's not a mirror image, it's likely to be a counter offer, which will destroy the original offer, which can no longer be accepted. You've got to distinguish, though, a request for further info from a counter offer, and we saw that in Stevenson and McLean. The acceptance must be communicated, and sometimes a specific form of acceptance must be used. So if the person making the offer has specified the method of acceptance that they want, whether it be telephone or post, then if the person accepting doesn't use that correct method, the acceptance is likely to be invalid. We've got battle of the forms situation where the last shot rule applies, where businesses are contracting using their own standard forms. We would just use the last one that was used in the case. And we ended by looking at the postal rule, that where post is going to be used in a case, acceptance is valid the moment it's put in the post box, even if it never arrives, but we can avoid it by saying that we must have notice of the letter. And more modern methods of communication, key cases Thomas, where we think that in most cases, emails will follow the postal rule, and Adams and Lindsell.